Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association's Antitrust Law Section. Today's topic is, what is fair? Four tips for complying with FTC Fair Advertising Guidelines. My name's John Roberti. Today we are going to be talking about FTC consumer protection guidelines and guidance on compliance with fair advertising. It's an area that is absolutely fascinating, and in some ways sort of complicated. There's a lot of subtlety to it. We have a really great guest who is going to help us find our way through those traps. My co-host is Anora Wang. Hi, Anora.
Hi, John.
Anora, what are we covering today?
We're today here learning about 4 legal traps for advertisers from a current enforcer's perspective. Sometimes as a consumer, we see ads that's so crazy that employs various kinds of tricks and think it's crazy that they're not in legal trouble. Today, Lesley, who is our guest today, will tell us that's not the case, and there are several common legal traps for those advertisers.
Well, you started to tell us. Who is our guest today?
Well, Lesley Fair is a senior attorney with the Federal Trade Commission's Bureau of Consumer Protection. Lesley has represented FTC in numerous investigations of deceptive advertising and consumer fraud, and she has contributed numerous chapters to books on consumer protection law. And also in relation to ABA, Lesley is co-chair of the Jenna Steiger Fellowship Committee.
Well, great. Let's bring in our guest. Lesley Fair, welcome to the program.
Thank you, John. Thank you, Anora.
Hi, Lesley. So tell us a little bit about the most common traps that you see from an enforcer's view that that would get those advertisers in trouble.
I think there are 4 main traps that get advertisers in trouble. And I say this from my perspective as a staff person spending 32 years at the Federal Trade Commission in this area. And I'll give you a hint. They all either rhyme or have alliteration, because let's face it, we're advertising people in BCP. The first is perception deception. The second mistake is a proof goof. The third is a disclosure delusion. And the fourth is a tech trap.
Right. Let's start with the perception deception. So what do you mean? Is that deceiving consumers from advertisers' perspective, or how are they playing tricks on our perceptions?
I think the most important thing for advertisers to remember is to look at ads from the point of view of the target market, from real people. Not from attorneys, not from scientific experts, to look at things from the way consumers are going to actually look at an ad, and also just to take human behavior into account. I'm thinking of one case that the FTC brought a number of years ago with the very generic name Access Resource Services. What in the world could they be? I think of them in another way. They were the famous ad with Miss Cleo, the infomercial psychic. That was a case where the FTC returned over $500 million back for consumers. Miss Cleo, first, well, I shouldn't say Miss Cleo. She had a lovely lilting island accent, but she was an actress. The ad claimed that the consultations were free when they weren't. They charged more than the advertised price for a minute, and if consumers balked at paying undisclosed fees, they threatened to ruin their credit. So that returned $500 million back for consumers. And I think that's an important point, where that money goes. In BCP cases, it goes back to the pockets of consumers who were taken advantage of in this area.
Lesley, I just found it remarkable. $500 million, that is, and probably coming from people who, some of whom may not really be able to afford it's troubling.
It's very troubling. We get a lot of feedback and letters from consumers when they do receive money back on their credit cards or checks back from the FTC. One very recent one we got in a payday lending case that returned, again, in excess of $500 million to consumers. The person wrote a public comment on the FTC website that said, "First, thank you, Jesus. Second, thank you, Federal Trade Commission." I didn't mind second billing there, given who else was involved. But we really know that a check for $400 or a check for $25 back to consumers who were defrauded, who were deceived, really makes a difference.
Yeah, it's the principle, but it's also meaningful.
Very meaningful to those folks. So in a case like that, it's important to remember the FTC doesn't choose winners in the marketplace. If people want to call infomercial psychics, that's their right. We have a right to buy sort of crazy stuff. However, if they say it's $3.95 a minute, they have to charge $3.95 a minute. If they say it's free, it has to be free. Another case like that, Anora, was the FTC's recent settlement with Neiman Marcus. And I think this shows a slight difference in my many decades at the FTC. The company advertised a faux fur collar coat. However, we allege that the faux fur collar was made of fur.
Wait, what is faux collar? So
this was the
fur, not fur.
Well, it was advertised as faux fur. I call this our faux fur collar case.
Oh, I see.
Because, of course, the allegation was it was made of real fur. Now, the decision about whether to wear fur is not for the FTC to decide. It's for consumers to decide. But if a company says it's fur, it's got to be fur. If a company says it's faux fur, it has to be faux fur. What's interesting in this area is when I started at the FTC, our cases were in the exact opposite direction. It said it was chinchilla when it was really polyester.
Right.
But for many consumers, this has become material in the opposite direction. They don't want to wear fur. And so by being told, you're safe, it's faux fur, and then finding out it's fur, that's another example where, again, the FTC doesn't choose that. The consumer is king and queen.
Exactly.
They get that choice.
Yeah, as a consumer, I might be buying for some environmental consciousness or some, I don't know, I might be allergic to fur. So there are reasons that I make my choice, but I don't think the advertisers get to play tricks on how I should be perceiving. I guess that ties to your title with this common type of legal trap. It's playing tricks on perceptions. Now, can we move on to the second type of legal traps, which is the proof goof?
I think that relates to the FTC's substantiation standard. When companies make objective product claims, there's a long-standing legal principle in consumer protection case law that they must have in hand before they advertise substantiation, competent and reliable evidence that proves the accuracy of their statements. Again, this is for objective product claims. So an awful lot of the FTC's cases on the consumer protection side get very scientific. We're dealing with whether it's a one-tail or two-tail statistical analysis. We deal with what the standards are for clinical testing. Some of them are more technical than others. This one I don't think was really technical. The FTC settled a case dealing with Kellogg's Frosted Mini Wheats. The company didn't just say it was a yummy cereal. The company claimed that the product was, quote, clinically shown to improve kids' attentiveness by nearly 20%. For a parent, that's a very material claim. The FTC's allegation in going behind the study and looking at it was that the actual average was 10.6%. Again, lawyers, I'm not a mathematician, but I have a vague recollection from arithmetic class that 10.6 gets rounded down to 10. It does not get rounded up to 20.
Even if it goes to 11, it's still not 20.
11 is fine. But, so that's an example where the FTC said that the company had taken the statistical evidence and had put a deceptive spin on it. Right. They're certainly fine to advertise what the studies actually show, but that's an example where we believed that the company deceived consumers about that. Then you have a much more scientifically technical case. This was the FTC's Palm Wonderful case.
Right, I heard about that.
It was, this was a very big case. It went, an administrative trial. It went to the commission. It then went to the D.C. Circuit. The Supreme Court ultimately denied certiorari. But it dealt with, a very popularly advertised national product. And it wasn't, had the company just said, listen, it's a delicious juice with lots of nutrition, we wouldn't have been at the D.C. Circuit. Instead, the company touted studies that ostensibly showed that drinking Palm Wonderful daily would treat, prevent, or reduce heart disease, prostate cancer, and erectile dysfunction. That's a juice, my friend, if they had done that. The FTC's allegation was that the company's studies did not match. In effect, the substantiation did not fit the claim, leading the D.C. Circuit, not me, the D.C. Circuit, to say many of these ads mischaracterized the scientific evidence concerning the health benefits of Palm's product with regard to those diseases. And when companies are making anti-cancer claims, heart disease claims, they need solid randomized clinical testing. And we allege that the company engaged in a proof goof by not having that.
Well, for that case, I wonder, wouldn't FDA be also be involved, because it involves cancer and all kinds of health? The differentiation between what's FDA and FTC comes from one of those memoranda of understanding. Only in Washington do we refer to moo and not mean cows, but this is something entirely different. The advertising of these kinds of products is the FTC. The labeling of those products is the FDA. The one exception on the consumer protection side is a prescription drug advertising, which is primarily handled by FDA. Yeah.
However, we work regularly. My first speed dial number on my phone is to the FDA. We work regularly with our brothers and sisters there. But food advertising, dietary supplement advertising, cosmetic advertising is the primary purview of the FTC.
I see. Would you also characterize food and I guess health-related products to be the most common type of products that got into this proof goof type of legal trap?
I think it depends on sort of the decade that you're looking at. I'd suggest in the 90s, it was, food claims were really one of the FTC's big focuses. We still get involved, but I think much more these days are cases dealing with herbal supplements, dietary supplements, these kinds of products, which are treated differently by the FDA as a result of a statute that was passed a number of years ago. So the FTC really looks very carefully at dietary supplement claims, especially when they're making representations about things like heart disease, cancer, arthritis, diabetes.
Right. Let's turn to the third categories of legal trap that you have characterized as disclosure delusion. Tell us about that.
I think there are a lot of advertisers that mistakenly think that fine print can cure an otherwise deceptive ad. And when I say fine print, I also mean a buried hyperlink or something buried into a privacy policy or end user licensing agreement. Let me give you just a simple example. The FTC took action relatively recently against a large regional car dealership, Casino Auto Sales. The advertisement very prominently showed kind of a mint-looking used Chevy Tahoe advertised at $17,995. Nice deal. It's a cream puff, really. The problem was, down in a very tiny footnote on the newspaper ad was the information that the $17,995 was the price after the consumer had put $5,000 down. So the actual price was $22,995. So that's an example that's just not going to work there.
Right.
If it's $22,995, say that, rather than requiring consumers through a footnote to do that kind of math. Another example was the FTC's settlement with Nissan North America and its advertising agency, TBWA. The ad looked like a YouTube video that had some I'll call them some bro-ish dudes, sort of using dune buggies and having fun. You could hear in the background, yo, dude, gun it, bro. And it showed a dune buggy getting stuck on a dune. What are they going to do? Up comes the Nissan truck that, at a very extreme angle, appears to push the dune buggy up to the top of the dune. In fact, the FTC alleged the truck was not capable of doing that. Both the truck and the dune buggy in the actual show had been dragged up there by cables, and that the camera angle was adjusted to make the hill look much steeper than it really was. This is not very far different from, cases that the FTC has brought against Volvo, against a major shaving cream company in the 60s. That case went to the Supreme Court, standing for the proposition that product demonstrations have to be truthful. Now, where is the disclosure part? In fine print, I would call it white against sand dune color. Mm-hmm. It said fictionalization, which I think is a 7-syllable word. It's not quite clear what it means in that context, the FTC alleged, and simply putting fictionalization on the ad does not change the impact there.
Can I ask you a couple of follow-up questions? So if they had put just kidding, would that have helped?
I think a lot depends on how clear and conspicuous the just kidding is. Certainly, we've got a sense of humor, too. It may not seem like that sometimes. We do. We appreciate that there can be ads that are intentionally over the top, and that's great. We like those, too. But you better make sure that they are intentionally over the top. The most important thing to remember in this area is basically what the headline giveth, the footnote cannot taketh away, which is important, I think, for companies to bear in mind when they're doing any kind of fine print disclosure. My suggestion to attorneys is the minute somebody says, let's just put that in the footnote, let's put that behind a URL, that's a red flag right there. And what it probably says to companies is you might want to be rethinking your ad claim rather than worrying about the font size. I get that a lot. Clear and conspicuous. Is it 2-point? Is it 4-point? Do you like the German? Do you like the Times New Roman? We like it clear. We like it read. We like it understood by consumers.
Right, Lesley, but I do, even though I'm a consumer, but I do have a little sympathy for advertisers here. So for like drugs, we commonly see these long claims of side effects that as a consumer, I don't enjoy watching or listening, and I know they are legally obligated to do so. But if that's something that's not really helpful to the advertising, and then it's true, and it's there's just no way that you can put all of them up front. So what would be the FTC's guideline, I guess the main takeaway advice for these kind of advertising?
The kind of things you're talking about, Anora, are of course required by the FDA, not the FTC. However, the FTC's position is that it needs to be, again, clear and conspicuous. Mm-hmm. That it needs to be, I was talking recently to major car dealers, and they said, we just don't know how to make things clear and conspicuous. My response was, you guys invented the 40-foot inflatable Uncle Sam on your showroom floor. When you want to make something clear, you can. We're not talking about all information. We're just talking about information necessary to prevent an ad from being deceptive. You want to put your trademark information in invisible ink. Your IP attorney may not like that, but that has nothing to do with the FTC. We're talking about disclosures necessary to prevent deception.
Right. So that's helpful. Let's turn to the last legal trap that you have mentioned. It's called the tech trap.
The tech trap is that when advertisers forget that established law applies to new technologies. I have the slightly less impressive distinction of bringing the FTC's second internet case in about 1994. I missed bringing the first and going down in history. I brought the second. But it's important to remember that those principles still apply, even in new technologies. A lot of companies think they're writing on tabula rasa, when in fact they're writing, I don't think my Latin is right, on tabula 114 years of precedent. And that the same truth in advertising standards that apply in other instances apply in the tech area too. I think the other area that's important for lawyers to emphasize, both to startups as well as tech companies in this area, is, it may be cool to technologically do it, but just because you can doesn't necessarily mean that it's a good idea for consumers from a consumer protection standpoint. I'm thinking our settlement with Aaron's Rent to Own. The allegation was that the company knowingly played a direct role in their franchisees' use of software on their rent-to-own computers that secretly monitored consumers, including taking webcam pictures of them at home without their knowledge. Does the technology allow companies to do that? Sure. But how could any business think that that's a wise idea to do without consumers' knowledge and permission? Then we have a case like TrendNet. This was a settlement, the FTC's first Internet of Things case. These were video cameras that consumers used to monitor their homes or businesses remotely for either security purposes, baby cams, nanny cams. However, lax security practices exposed consumers' private home life for public viewing. So somebody sitting in their grandparents' basement in their sweats could watch what was going on in your child's bedroom or in your place of business. The irony, of course, is that the form of camera had the unfortunate name of Secure View, kind of a problem from the FTC standpoint, but we alleged that that was another kind of deceptive practice.
Lesley, I guess I would want a little more explanation on why that is an advertising problem. It appears to me that's more of a decision about the product designing, right? Whether you should include that feature that, enables you to do certain things that's kind of, questionable, not so much how you claim what they can do.
Advertising under our statute, courts have given it the broadest possible meaning. It basically is everything that is not pure constitutionally protected speech. And let's face it, why, how the company sets up its product is part of their marketing strategy to sell their product. The company made the choice to call that Secure View. They could have called it any number of other things.
Right.
It was an intentional decision to say to consumers, we allege, don't worry, this is secure. So to us, that is part of advertising.
Right. That also, to me, sounds like a mixture of the kinds of previous legal traps that you have described. Sounds like it's purposely, playing tricks on my perception on what secure is, and then it also sort of mischaracterized what the nature the product is. So that's perfectly helpful to me to understand. But would you say a little more how the FTC's guidelines would provide some pathways for advertisers to stay miles away from these kind of legal traps?
Well, I think we have an awful lot of plain language guidance, both for businesses and general practice attorneys who may not be doing this every day. We have a separate website, business.ftc.gov, that includes all of that information. We have hundreds of brochures that explain in plain language, no footnotes, no case citations, how to make clear disclosures. We have a document called Start with Security, which gives kind of the 10 tips on avoiding a data security oops for a company. So we have lots of guidance for businesses in this area. We also have our several times a week business blog, which evaluates just about every FTC case and on the BCP side and explains the lessons that advertisers, business people, and attorneys should take from that case.
That's super helpful.
Yeah, and what we'll do is we'll put links up on our website that will allow folks that want to learn more about these guidance documents you're talking about to find them.
I think I'd really appreciate that. I should, in the interest of full material connection disclosure, say I am the FTC's primary business blogger, which after talking for 20 minutes, I'd like to think would shock most people at this stage. But we do offer that information regularly about every case.
Can we go back? This would be helpful for me. Can we go back through the 4 one more time? And can you just tell me what they are? And maybe we can just run over them. And then I maybe want to ask you a little bit about yourself.
Sure. Perception deception is mistake number 1, when advertisers look at ads and practices from the point of view of literal truthfulness or attorney truthfulness rather than from how consumers are going to look at it. A proof goof. when companies' purported substantiation doesn't fit the advertising claim. A disclosure delusion is the third, when advertisers mistakenly think that a fine print footnote, a buried URL, a block of text will cure an otherwise deceptive ad. And the fourth one is the tech trap, forgetting that even in new technologies, the 114 years of FTC precedent still apply.
Lesley, this has been really helpful for us. I think it'd be useful for our listeners maybe to learn a little bit about you. One question I'd like to start with, we always read that the FTC is one of the best places to work in the federal government. Tell us, what do you like about your job?
Well, I can say from my perspective, the idea of the FTC being one of the best places to work is a substantiated advertising claim. I've been there more than 3 decades. And what we find, it is first, the work is inherently interesting. I get to watch. Watch TV. I get to surf the internet. I get to look at that kind of advertising stuff, which I find just inherently interesting.
I do that too, but I don't get paid for it.
Yes, that's your mistake, John. That's your mistake. I also think there's just an ethos of public service. Those of us who come tend to stay. Because it is a place where we realize when, the first time I walked into a court and the judge said, who represents United States consumers?
Right.
And I looked around for a second thinking, boy, there must be somebody pretty darn impressive here, until I realized, holy smokes, he's talking about me. And I realized what an honor it is to go into court in the interest of truth, justice in the American way, representing who, at least from my perspective, are the most important clients out there, which is the public interest.
I've always kind of found folks, particularly in consumer protection, be kind of fun too. I'm going to ask you, and you can deny this, or it might be top secret information, but I've heard rumors that sometimes very important internal memos have covering notes that are written in haiku.
Indeed they are. I don't know where you would find that secret information. I think what's important is, we are steeped in BCP in the advertising world, in the tech world, in popular culture. The amount of time that I spend watching the, Real Housewives of Parsippany is really kind of embarrassing. But, we are surrounded in BCP by our culture because it's part of the job. So that's why I think it's a pretty fun place to work.
Well, what advice do you have for a younger lawyer that would want to do what you do?
I think there are a couple things. I think certainly this is the one time, I used to do a lot of recruiting for BCP, and I'd ask the question, what ad have you seen recently that really just got your goat, that if you had the authority, you could do something about? And let me tell you, I've been a law professor on the adjunct side for 36 years now, and let me tell you, law students tend to answer that question, well, I'm much too busy to be watching television or to be, wrong answer. The first thing is just to have your ear to the ground on popular culture. That, to me, is not a hard thing. That's a beauty of the job. The second is to take advantage in law school and early in somebody's career to network, to get to know people, to find out what the area is about, and most importantly, not to stop until they find something that they absolutely love. That's what happened to me 3 decades ago when I came to the FTC.
That's great advice.
So, Lesley, tell us something that's surprising or unusual about yourself that we wouldn't know about you if we only knew you professionally.
Well, I'm going to go way back for this one. We're here in a sound studio in Arlington, Virginia. I actually went to high school about a mile from here at a place called T.C. Williams High School that got famous from a movie called Remember the Titans. But why this neighborhood really resonated me with that question is that I used to have a major rival at the local high school, Yorktown, here in Arlington. I lost to her in every speech competition, every science fair, everything like that.
Is she the advertiser now?
No, she's Katie Couric.
So, again, you brought the second internet case at the FTC, and you finished second to Katie Couric in a lot of stuff. That's really not all that bad.
Not all that bad, but she won, and I haven't forgotten it.
we'll let her know. And now it's the time for our final section, which we call the Curious Hat.
And now it's time for the Curious Hat.
The Curious Cat is a
Cat.
is a hat that
Not a
we.
cat.
It's a hat. We asked the guests to pick questions out of a hat. Today we have lost our hat, so we're going to ask Lesley to pick a number from 1 to 20, and we will ask the question that corresponds with that number.
My lucky number 18.
Okay, question number 18 is: are there any TV series that you are watching or binge watching now?
Oh, that is my lucky number. Yes, I'm already on episode 5 of The Crown, season 3.
Oh, that's great.
Which I'm loving. And I think the best thing about it is that I watched season 1 through 5 without ever getting up off the couch. So that to me is a sign, no breaks, no running to the fridge. That's the sign of a good one. I am also absolutely addicted to the television sedative that is the Great British Bake Off, which I think is fascinating.
The Brits are so nice on that program.
It shocks me because all they're fighting for is a plate. That's it. And they help each other out.
I was with some colleagues in the United Kingdom, and I tried to convince them to watch Nailed It, and they convinced us to watch the Great British Bake Off, and it turns out they're very different programs.
Well, I think Nailed It is very American, very, very American. Obviously, the Great British Bake Off is otherwise. I can recommend to you the French version of Nailed It and the version of Nailed It from Mexico. They're interesting shows that I think really reflect the culture of where they're from. But binge watching TV, thank you, John. That's my specialty, yeah.
And with that, we will close out this episode of Our Curious Amalgam. We will see you next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.